time to put a stop to it. It is strike law that if a defendant misbehaves or acts unruly in the courtroom, his trial can be done in his absence. As stated by the defendant this morning, he said he has put in his defense. He is not calling any witness, that he is only putting address. And I will get to the issue of getting address in the judgments. We are not taking evidence this morning. Is to take judgment and sentence if possible. It is based on that I hereby make an order that because of the unruly behavior of defendants, his aggressiveness and violent nature, I hereby make an order that the judgment and other proceedings proceed in his absence. I take my judgment. The defendant was arraigned before his court on 7-count charge, which reads thus. Count 1. That you, Nnamdi Kanu, male, adult of Afaranuku Ibeku in Umo North Local Government area of Abia State, sometimes in 2021, being a member and the leader of indigenous people of Biafra, IPOB, a proscribed organization, did commit an act in furtherance of acts of terrorism against the Federal Republic of Nigeria and the people of Nigeria by making the broadcast received and heard in Nigeria within the jurisdiction of this court, with intent to intimidate the population, and you threatened that people will die, the whole world will stand still, and you thereby committed an offense punishable under Section 1, Sub 2B of the Terrorism Prevention Amendment Act 2013. Count 2. That you, Nnamdi Kanu, male, adult of Afaranuku Ibeku in Umo here North Local Government area of Abia State, sometimes in 2021, did commit an act in furtherance of an act of terrorism against the Federal Republic of Nigeria and the people of Nigeria, made a broadcast received and heard in Nigeria within the jurisdiction of this honorable court with intent to intimidate the population. You issue a deadly threat that anyone who flouted your seat at home order shall write his or her will. As a result, banks, schools, markets, shopping malls, fuel stations, domicile in the eastern states of Nigeria were not open for businesses. Citizens and vehicular movements in the eastern states of Nigeria were grounded within the jurisdiction of this honorable court, and you thereby committed an offense punishable under Section 1, Sub 2B of the Terrorism Prevention Amendment Act 2013. Count 3. That you, Nnamdi Kanu, male adults of Afaraku Ibeku, Umo North Local Government of Abia State, on dates between 2018 and 2021 within the jurisdiction of this honorable court, profess yourself to be a member and leader of indigenous people of Biafra, IPOB, a proscribed organization in Nigeria, and that you thereby committed an offense contrary to and punishable under Section 16 of the Terrorism Prevention Amendment Act 2013. Count 4. That you, Nnamdi Kanu, male adult of Afara Nuku Ibeku, Umuohia North Local Government Area of Abia State, on date between 2018 and 2021, made a broadcast receipt and had in Nigeria within the jurisdiction of this court in furtherance of an act of terrorism against the Federal Republic of Nigeria and the people of Nigeria, in which you incite members of the public in Nigeria to hunt and kill Nigerian security personnel, and that you thereby committed an offense punishable under Section 1(2)(h) of the Terrorism Prevention Amendment Act 2013. Count 5. Nigeria within the jurisdiction of this court, in furtherance of an act of terrorism against the Federal Republic of Nigeria and people of Nigeria, in which you incite members of the public in Nigeria to hunt and kill family of Nigeria security personnel, and that you thereby committed an offense punishable under Section 1(2)(h) of the Terrorism Prevention Act 2013. Count 6. That you, Nnamdi Kanu, male adult of Afara Nuku Ibeku in Umuohia North Local Government Area of Abia State, date between 2018 and 2021, made a broadcast receipt and had in Nigeria within the jurisdiction of this court in furtherance of an act of terrorism against the Federal Republic of Nigeria and the people of Nigeria, in which you directed members of the indigenous people of Biafra, IPOB, a proscribed organization, to manufacture bombs, and you thereby committed an offense punishable under Section 1(2)(f) of the Terrorism Prevention Amendment Act 2013. Count 7. That you, Nnamdi Kanu, male adult of Afara Nuku Ibeku in Umuohia North Local Government Area of Abia State, on date between the month of March and April 2015, imported into Nigeria and kept in Uguluzo in Ihiala Local Government Area of Anambra State, within the jurisdiction of this court, a radio transmitter known as Tram 50L concealed in a container of used household item, which you declare as used household item, and you thereby committed an offense contrary to Section 47(2)(a) of the Criminal Code, Cap C45, Laws of the Federation of Nigeria 2004. In discharging its burden of proof, the prosecution called 5 witnesses as follows. 1. Mr. AAA as PW1, Mr. BBB as PW2, Mr. CCC as PW3, Mr. DDD as PW4, Mr. EEE as PW5. The prosecution also tendered the following, which were admitted in evidence by these courts. 1. A document titled Items Recovered from Nnamdi Kanu of Radio Biafra at Golden Oakley Hotel, located at number 42/44 Airport Road, Lagos, on the 15th day of October 2015, was admitted and marked as Exhibit PWA. 2. This titled Interview with Nnamdi Kanu and a Certificate of Compliance filed on the 28th day of April 2025 were admitted and marked as Exhibit PWB and PWB2 respectively. 3. The statement of defendants dated 15th day of October 2015 was admitted and marked as Exhibit PWC. 4. A process titled A List of Items of Nnamdi Kanu filed on the 19th day of March 2024 was admitted and marked as Exhibit PWD. 5. 4 bags as identified by PW1, Mr. A, were admitted and marked as Exhibits E bag A to E bag D respectively. 6. Items in Exhibit E bag A as identified by PWA were admitted and marked as Exhibit E bag A1 to E bag A13 respectively. 7. Items from Exhibit E bag B were admitted and marked as E bag B1 to E bag B32 respectively. 8. 10 items from Exhibit E bag C, Exhibit E bag C1 to Exhibit E bag C10 respectively. 9. Contents of Exhibit E bag D were admitted and marked as Exhibit E bag D1 to Exhibit E bag D17 respectively. 10. A letter dated 10th day of June 2021 from the Attorney General of the Federation and Minister for Justice addressed to the Director General Department of State Service was admitted and same was marked as Exhibit PWF. 11. Device to it, flash drive, black and red in color, and a certificate of compliance were admitted and marked as Exhibit PWH and PWH1 respectively. 13. A disc in respect to the statement of the defendant taken on the 17th July 2021 and certificate of compliance thereto were admitted and marked as Exhibit PW1 and PWI and PWI1 respectively. 14. Federal Republic of Nigeria of Official Gazette number 99 in volume 104, dated 20th day of September 2017, titled Terrorism Prevention Order 2017, was admitted and marked as Exhibit PWG. A document to its medical report titled Late Ahmed Gula, hospital number 013931, dated 18th July 2021, was admitted and marked as Exhibit PWK. 16. A certified true copy of the judgment in HIN/FR/2021 between Nnamdi Kanu versus Federal Republic of Nigeria and 7 others, delivered on the 19th day of January 2022, was admitted and marked as Exhibit PWL. 17. A certified true copy of judgment in FAC/UM/CS/30/2022 delivered on 26 October 2022 between Nnamdi Kanu versus Federal Republic of Nigeria and 2 others, was admitted and marked as Exhibit PWL. 18. A certified true copy of the judgment in suit number E/2023 between Mazi Nnamdi Kanu applying for himself and on behalf of members of indigenous people of Biafra IPOB versus Federal Republic of Nigeria and 4 others, delivered on the 26th day of October 2023, was admitted and marked as Exhibit PWN. 19. A document titled Lagos State Judicial Panel of Inquiries on Restitution for Victims of SARS-related abuses and other matters, was admitted and marked as Exhibit PWO. 20. A faster flash drive with certificate of compliance were admitted and marked as Exhibit PWP and PWP1 respectively. 21. A disc titled Interview with Sahara Reporter with certificate of compliance was admitted and marked as Exhibit PWS. 22. The search warrant dated 28th day of October 2015 with search reports was admitted and marked as Exhibit PWT. 23. A disc mask radio transmitter extra with certificate of compliance was admitted and marked as Exhibit PWU. 24. The statement of Benjamin Madugugu dated the 3rd day of November 2015 was admitted and marked as Exhibit PWD. 25. A SanDisk flash drive with its attachments and also with certificate of compliance was admitted and marked as Exhibit PWW. 26. Online printout of Vanguard newspaper and certificate of compliance was admitted and marked as Exhibit PWS. 27. A container containing a transmitter was admitted and marked as Exhibit PWY. 29. A certified true copy of report on request for professional assessment of radio transmitter dated 25th day of November 2015 was admitted and marked as Exhibit PWA2. 30. Certified true copy of Vanguard newspaper of 3rd day of July 2021 from National Library was admitted and marked as Exhibit PWB2. 31. The payment received with revenue collection receipt from National Library of Nigeria receipt number 19128 of 7th June 2025 was admitted and marked as Exhibit PWC2. 32. The report of assessment of the damage as a result of exercise was admitted and marked as Exhibit PWD2. 33. Death reports and certificates of security officers was admitted and marked Exhibit PWD2A. 34. Certificate of compliance was admitted as Exhibit PWD2B. The defendant is the leader of the indigenous people of Biafra group. He stated that his first contact with the defendant was on the 14th day of October 2015 when he was detailed by his commander in the Lagos office to go to Estancia Airport Hotel to arrest the defendant. PW1 stated that he went with some other officers, with one of them named Bolaji Adeyemo. On arrival at the hotel, they introduced themselves and informed the hotel workers that they were there to arrest the defendants. PW1 even showed the receptionist the photograph of the defendants, but he was told that the defendant was not in the hotel. He then asked for the guest manifest, but the name of the defendant was not on the manifest. So PW1 reverted to his commander, who then ordered that they conduct room-to-room search. In the process, they enlisted the cooperation of the manager of the hotel, who availed them of the master key of the rooms. Shortly after, Bolaji called PW1, who was downstairs, with his director, informing him that he had found the defendant in room 303. On getting to the room, PW1 stated that he met a young lady who was later identified as Miriam Ibezimako. He introduced himself to the defendant and informed them of the purpose of their visit. Thereafter, they proceeded to arrest the defendants, who initially resisted arrest. PW1 further stated that during the encounter, Bolaji intervened to calm the situation after the defendant executed him. Whereupon the defendants eventually agreed to follow them to the station. PW1 stated that the room looked like a broadcasting studio due to the broadcasting items mounted on the table, such as microphone, a tripod and airport, transmitter, mixer, and cords. PW1 PW1 said they located the defendant at about 23 hours of the day. When they arrested him, they also arrested him with some of his baggage, which was listed in the sheet of papers which the defendant signed. He said the items recovered were about 70, and it took some time for him to complete the inventory. PW1 stated further that on the following day at about 9 a.m., he was instructed to take the statement of the defendant. So he took him to the interview room and recorded the statement from him, which was captured on video. PW1 stated that at the time he took the statement of the defendant, the allegation against him was that he was the founder and leader of an organization known as the Indigenous People of Biafra, IPOB, through which he allegedly agitated for the violent secession of Nigeria's southern eastern states, south-south states, and as well as two states from the north-central region, namely Benue and Kogi. Also, that he founded Radio Biafra, through which he broadcast his intentions, inciting the general public, particularly his followers and those who are sympathetic to his cause, to violence, to achieve the solution he was agitating for. PW1 then stated that he issued the defendant with his service statement form after administering the cautionary word onto the defendant, and then he proceeded to write down his statement. The defendant signed the statement and same was countersigned by him, PW1. PW1 stated further that the international passport of the defendant was recovered and brought to them the following day by the manager of the hotel, who found the passport on the interview of the defendant. He admitted to the allegation against him that he is indeed the founder and leader of Indigenous People of Biafra Group, and that he operated Radio Biafra, which is not registered by the Nigeria Broadcasting Commission or any other government agency. In addition, the radio station broadcasts information across Nigeria and the world at large. Under cross-examination, PW1 stated that he was one of the officers who interviewed the defendant, and that during the interview, the defendant's lawyer was not present. PW1 said he took the statements of only the defendant, and that the items recovered from the defendant did not look offensive. Also, that they did not analyze the phone of the defendant as they thought it was immaterial at that time. He said he did not personally arrest and investigate any person who may have committed any crime on the instigation of the defendant. Furthermore, that he did not investigate the lady arrested with the defendant to see if she was aiding the defendant in terrorism activities. PW1 denied knowing if the defendant's name named any other person as a co-conspirator, or if any other person is standing trial on a related charge. PW1 said, from his knowledge, the defendant had the support of persons like Simon Ekpa in his agitation for secession. He said the defendant incited others to destroy public properties. PW1 stated that even though there have been killings in other states, such as Kaduna, Zamfara, as far as he could tell, those killings were not product of agitations for separation. He said he knows that IPOB was prescribed in 2017, but he does not have other details of the matter. PW1 stated that there are people who carried out the order of defendants, including sit-at-home order, in which people have been killed for disobeying the directive. He stated that he is not aware that a charge against the defendant for inciting persons to kill military officer was struck out by the court. Under re-examination, PW1 stated that the agitation of the defendants in this case is for a call for separation from the country for the southeastern, south-south, and some north-central states. PW1, Mr. BBB, is an officer of the Department of State Service. He stated that the defendant is a member and leader of prescribed terrorist group called IPOB, which means the indigenous people of Biafra. PW2 also stated that he was assigned to take the statements of the defendant on the 17th day of July 2021, and that the purpose for the statement was for him to answer to the allegation contained in the letter sent to them by the Honorable Attorney General of the Federation. PW2 stated that the defendant is also the founder of Eastern Security Network, which is the armed wing of IPOB, and that he also established and operates Radio Biafra illegally, which was not registered with the Nigerian Broadcasting Commission, that the defendant told him all this during their interactions. PW2 further stated that during his interview, he was with his director and 4 other officers, as well as the defendant and 2 of his lawyers, namely Mr. Aloy Ejimako and Abila Topchak. That the defendant admitted that he made broadcasts inciting people to burn, kill, and collect weapons from police officers wherever they see them. That the defendant also made written statements on the same day. He said the defendant admitted founding the Eastern Security Network, and that he admitted making broadcasts where he ordered his followers to ensure that whoever flouts the ceased had so ordered the attack, and it led to the death of many people, including destruction of properties. PW2 further stated that one of the unfortunate persons who lost his life includes Ahmed Gulak, the former senior special assistant to the President Goodluck Jonathan, who died on 30th May 2021, and also that the defendants made broadcast on the 20th day of October 2020 during the NSAS process, which led to the destruction of properties, including Lagos High Court building in Igbo, as well as part of the Muritala Mohammed Airport. Further, that the defendant asked the floor to behead any military or police officers, and this led to the killing and beheading of a military couple in Odu, in Imo State. In addition, it was established that a retired judge, Honorable Justice Stanley Nnaji, was also killed as a result of the defendant's broadcast. PW2 stated that the aim of the defendant was the creation of the Republic of Biafra by any means possible, including war. Under cross-examination, PW2 stated that the video statement of the defendant was a complete reflection of what transpired during the interview, even though the camera was focused on only the defendant and his counsel. He stated that he does not know if and how long the defendant was kept in solitary confinement prior to the statement being taken. He also said during the interview, defendant did not tell him that he was frustrated, that he is not aware of the status of Sarara reporters and whether it is registered. He said the defendant confirmed that he ordered seat at home in the southeast. PW2 confirmed that General T.Y. Danjuma, retired, has accused the Nigerian security forces of not being natural, of not being neutral. He said he is not aware that the Director General of DSS urged Nigerians to rise up and resist terrorism. He said he is aware that the NSAS movement was never classified as terrorist organization. He said the defendant was and remained a member of IPOD before and after it was prescribed by the court. Under re-examination, PW2 stated that Amotekun is not the same as Eastern Security Network, as Amotekun is recognized by law passed by the Houses of Assembly in the Southwest states. While Eastern Security Network is not registered, not recognized by any law, so it is an illegal association. PW3 is Mr. EEE is an operative of the State Security Service and have been with the agency for 27 years. According to him, the defendant is the leader and founder of indigenous According to him, the defendant is the leader and founder of indigenous people of Biafra, a proscribed terrorist organization, and also served as the director and broadcaster of Radio Biafra, which was used to incite the public. He stated that his first contact with the defendant was on the 21st day of October 2015, when he was instructed to interview the defendant to take a statement regarding the allegation about his activities in operating Radio Biafra, and also the founder of IPOP. He stated that on the first day, he invited the defendant to the DSS interview room at the National Headquarters, where he and 3 other officers interviewed the defendant, and also video recorded of the interview, which the defendant consented to. He said the defendant did not reduce his statement in writing until 23rd day of October 2021 due to complaint of his being tired and needing to rest on the 24th day of October. He said the written statements were then signed by the defendant when he finished writing. PW3 in his further testimony stated that during the interview of 24th day of October 2021, the defendant was confronted with video recording of interview with Sahara reporter. In that video, that he was agitating for the secession of Biafra and using Radio Biafra to incite members of IPOP against the Federal Republic of Nigeria. PW4 stated that further that on the 20th day of October 2015, through an intelligence, they discovered that the defendant smuggled a radio transmitter without the clearance sent to the Nigerian Customs Service, that it was hidden from view using household equipment and was contained in a container. PW4 stated that it was kept in the custody of one Benjamin Madugugu in Anambra. PW4 said he got to know all this when he was handed a video recording when the defendant was seen in the company of Madugugu inspecting the radio transmitter and taking ownership and carrying it as a game changer, which Radio Biafra will be broadcast through. Following an instruction from his superior, PW4 obtained a search warrant, and on the 28th day of October 2025 proceeded to the village where Benjamin Madugugu was and retrieved the radio transmitter. PW4 stated that when they opened the container, they found only the transmitter in it and asked Benjamin what happened to the other items, and he said the defendant came to inspect the. It's one individual named Chimeze who took the other items away, leaving only the transmitter in the container. He said Benjamin Madugugu wrote a statement on the 3rd day of November 2015 at the DSS headquarters, and he confirmed the result of the search. Benjamin Madugugu, when asked, did not produce any custom paper. Benjamin was initially arraigned along with the defendant until he jumped bail and the case was severed. He said, IPOD has made life difficult in Southeast due to the seizure at home order of the defendant, as well as the violence unleashed by IPOD. Further, the Eastern Security Network, which is the armed wing of IPOB, bears arms, engages in guerrilla warfare, where they attack security agencies such as the police and the Nigerian army. They also ensure compliance with the sit-at-home order. PW4 stated that in a particular broadcast of 30th day of May 2021, the defendant issued threats that anyone who defies his order of sit-at-home by opening their shop should be killed and the shop burnt. PW4 explained that Ahmed Gulak, the former
what's your Wi-Fi password?
Assistant to the former president Goodluck Jonathan, was killed on the day declared to be a sit-at-home, that he tries to take another route to the airport when he was shot by airport terrorists. PW4 said he was the first person at the scene and he found the lifeless body of Gulak on the road. He said that from the feedback he got from President of Southeast, the sit-at-home order had depleted the economy and activities in Southeast, and the people were living in apprehension for their safety. PW4 also said that he knew one who comes up identified as one of the dreaded commanders of Eastern Security Network, which real name is Kanikayo Andy. He described the Konzo as a ruthless commander who took direct orders from the defendant. PW4 further stated that in Konzo, on the 4th day of April 2021, the defendant made a broadcast in which he declared that Konzo would be buried specially. In PW4 continuing his evidence when he stated that the container containing his transmitter was recovered from the premises of one Benjamin Madibu, wherein the defendant had smuggled the radio transmitter into the country. The container also had some household items in it, which were later removed. Upon the matter being adjourned back to the court, PW4 confirmed that Benjamin Madibu indeed made a statement before the DSS during the statement taking, he had his lawyer, one Vincent Obeta, present with him. PW4 also stated that upon retrieving the radio transmitter, they brought the defendant and Benjamin Madibu together and confronted the defendant with the evidence. He stated that the defendant accepted ownership of the container and that the radio transmitter. He also exonerated Benjamin Madibu by stating that the items were only kept out. Benjamin Madibu to confirm and come and inspect the transmitter, which they duly came and wrote a report of the findings. The conclusion from the report as spread by PW4 is that the station known as Radio Biafra was not licensed by the Broadcasting Corporation of Nigeria. Neither does he have any permit to operate in Nigeria. That for an organization to bring in a radio transmitter, it must apply for permission from the regulator, who is in turn right to the security agencies such as DSS and the National Security Advisor for clearance before the regulator issue a license to import the transmitter into Nigeria. That in this case, no such license permission was obtained by the defendant before importing this transmitter. PW4 referred to a newspaper story where the defendant had ordered an attack on prison in Imo. That the defendant had ordered members of IPOB to kill security operatives. Also that investigation revealed that the defendant having ordered members of IPOB to bury Ikonzo in special way by using about 2,000 human heads. His men were only able to get 30 human heads. Efforts were made to arrest these IPOB members in Odu in a village bordering Anambra Valley. They met some members of IPOB with human heads hanging from a wire mesh and they also saw some of them eating human flesh, which they claimed was for spiritual fortification. They also saw as well where they dumped victims and beheaded bodies into. PW4 stated that he was part of the operation which comprised the DSS and the Nigerian. He also stated that the defendant has never denied making those state broadcasts and was even proud of making them. PW4 also stated that record shows that shows that between 170 and 200 security agents of the federal government were killed by IPOB and Eastern Security Network all over Nigeria. He knows some of these murdered agents, which includes his driver, one Shinemere Ereke, and their tactical leader who were killed in Umuma local government area of Imo State. PW4 stated that the defendant was in the habit of making inciting statements ordering his men to carry out attacks on security agents as well as political figures such as Uzodema, the governor of Imo State. He stated that their mode of operation is that they move in group in Siena and other confiscated vehicles, and from there they launch attack on security operatives. They also set up checkpoints vehicle in good working condition. The group also engaged in activities aimed at terrorizing their community. That this group is so brazen that they even write to traditional rulers informing them of their intention to attack them. They attack even in broad daylight, kill people, burn local government area of Imo State. That they raided the station, killed everyone. Was unfortunate, caught in the storm as he was trying to catch flight out of Owerri that day. PW4 said he was the first to get to the scene of that attack where he found the disease in the pool of his lot. He was informed by the divisional police officer in the area that the disease was in a taxi heading for the airport when the iPod and Eastern Security Network armed combatants identified him as one of their checkpoints and opened fire on him. The driver of the taxi identified himself as an Igbo man, but the deceased, even though he claimed he was an Igbo man, could not speak the language, and having observed a prayer mark on his forehead, his attacker shot him. The body was later moved and conveyed in a plane to Abuja on the directive of the former secretary to the government of the Federation, Boss Mustafa. PW4 stated that between 2019 and 2022, he was in charge of security enforcement in Imo, and he witnessed firsthand the activities of the defendant and his men. PW4 stated that the defendant is the leader of indigenous people of Biafra IPOB, as well as the founder and operator of Radio Biafra. He testified that the defendant used the said radio platform.
Network is really disturbing me.
Have you not connected with their
No, it didn't connect.
To incite members of the public to
It
hate
connected
persons
to
of other ethnic nationalities, Fulanis. PW4 further stated that through his broadcast, the defendant directed members of IPOD to attack and kill security operatives and to destroy infrastructures and symbols associated with federal government as part of his agitation for the establishment of Republic of Biafra under cross-examination. PW4 stated that he did not sign any of the investigation reports, and also that the transmitter came in the country through the Tinkan, that there are no records to show it came in through Lagos, save for the statement of the defendant that it came through the Lagos port. This also stated that IPOB was formed outside Nigeria and that Radio Biafra was operated outside Nigeria but broadcast within the territory of Nigeria as it was an online platform. He further stated that the defendant was arrested in Lagos with his broadcasting equipment. He said it is not the duty of the DSS to find out if the Radio Biafra was registered in London. PW4 stated that he and one of the officers were sent to Ugulu to recover the transmitter that they reported to the DSS headquarters in Orca, and from there they proceeded to where the container was located using coordinates on video showing the containers. They testified that the container contained one other items including 2 pump action guns, one of which was found in the bedroom of Benjamin Madugulu, that the said Madugulu is facing a charge of illegal possession of weapon before Inyako came. He also stated that even though the defendant stated that he does not like violence and crime, and that churches and other places of worship should not be attacked, his broadcast of 20th, 24th, 25th October 2020 clearly incited people to kill others. That the main cross of the defendant broadcast is the killing of Fulani herdsmen by raiding the forest of Southeast with AK-47 killing the innocent. He said he is not aware of any Fulani herdsmen being in Southeast Eastern states. PW4 admitted that Goodluck conducted the primary election that led to the emergence of the governor of Imo State, Hope Uzodinma, and that satisfaction over the declaration of Hope Uzodinma was still questioned. He stated further that even though Ahmad Goodluck was with 2 other persons in the car, he was the only one trying to not kill Igbo person who violates the sit-at-home order. He admitted that the defendant said iPod will compensate the person which lorry of onions was hijacked, but he does not know if the promise was fulfilled. PW4 stated that it was the police who investigated the killing of Ahmed Goodluck. He said during the sit-at-home everywhere, including farm, usually decided him trying an explosive device to himself at the point of arrest. He said during his time in Southeast, he did not arrest any native doctor making sham for kidnappers. Also, that the checkpoints of police and the army are still functional in the Southeast today. PW5, Mr. EEE is an officer of his department. Other investigators to travel around countries that occurred between 2020 and 2021 relating to the EndSARS movements. He stated that the assignments included obtaining records from head of security agencies in the states visited, particularly the states in the Southeast and FCT, obtaining reports of deaths and death certificates of security personnel who died, as well as public properties destroyed as a result of EndSARS protests and riots. PW5, while referring to Exhibit PWG today, stated that 8 policemen were killed in Abia, 16 in Enugu, 16 in Imo, 17 in Akwa Ibom, 16 in Cross River. There were 6 police officers killed in Lagos, 9 in Rivers, bringing a total of 128 policemen killed. With respect to military officers, a total of 37 killed. The DSS had to repair facilities were damaged and destroyed. Under cross-examination, EW5 stated that he only investigated the deaths of security who were killed during the NSAS protest following the incitement by the defendants who instigated protesters to kill security agents and even taught them how to manufacture Molotov cocktails to use in the process. He further said it is on record that defendants urged protesters to destroy public buildings in places like Lagos. He said he does not know if one of the protesters, Aisha Yusu, is sympathetic to Biafra or is a member of IPOB. He said he is aware that the police brutality was one of the causes of the NSAS protest and that the defendants urged people to take up arms against the government. EW5 said there is no part of the report stating the activities of IPOB or ESL. He also said all protocols relating to taking of photographs were duly observed. He said from pages 669 of the report, there are some visible dates on the photograph. PW1 stated that there is no portion of the document signed by himself as secretary of the Presidential Ad Hoc Committee of the committee that investigated the aftermath of the NSAS protest and the chairman of the committee. However, he stated that he certified the document and that the document was not certified after the proceedings of 12th day of June 2025. The defendants had filed a notice of preliminary objection dated and filed 16th October 2025 seeking for the following reliefs. 1. A declaration that they continue the prosecution of defendants under the Repeat Terrorism Prevention Amendment Act 2013 upon a prescription order obtained ex parte and without fair hearing violates Section 1, Sub 2, Section 36, 1 to 12 and 42 of the Constitution of the Federal Republic of Nigeria and Article 7 and 28 of the African Charter and is therefore null and void. 2. That a declaration that the Federal High Court ex parte order describing IPOB obtained without notice or hearing and why Justice Peter Iyako's official ruling that IPOB is not an unlawful society remains in force is unconstitutional, unlawful, and cannot ground criminality. 3. An order striking out or permanently staying counts 1 to 8, counts 15 of the amended charge dated 14th January 2022 for being barred by double jeopardy, having the same factual ingredient as count 6 to 14, earlier struck out by the Federal High Court. From Kenya, without extradition proceedings on due process violates Section 36, 1 and 9 of the Constitution, the Extradition Act, Cap E25, Law of Federation of Nigeria 2004, and Article 12 and 13 of the African Charter, thereby robbing the court of the jurisdiction. 5. An order nullifying all proceedings conducted in breach of the defendant's right to adequate facilities for defense, confidential communications with counsel and for fair hearing, particularly a dropping, seizure of legal materials and denial of unmonitored access. The notice of preliminary objection has 43-paragraph affidavit deposed to by Ms. Emmanuel Kanu is sending to the defendants. The affidavit has been exhibit and written address. In his written address, the defendant submitted inter alia that the Court of Appeal in CA/ABJ/C/25/2022 has ruled in his favor on the 13th day of October 2022, holding that his extraordinary rendition has divested the trial court from continuing his trial. Thus, the instant trial is unlawful and in disobedience of the order of the appellate court. The defendant relied on the case of Okafor versus AG. which he tried life to sustain these proceedings. He also submitted that his extraordinary percent of jurisdiction as the subject matter of this charge is subject upon the primary objection. In written address filed on 30th day of October 2025, the defendants substantially repeated the submission on the legality of the extraordinary rendition from Kenya in 2021, upon which he was brought back to Nigeria to face trial. He also raised an objection to the denial of his right to fair hearing, and that the charge was premised on repealed law, and thus the charge ought to be. This court will painstakingly consider this jurisdictional issue before going to the substantive issue if need be. Refer to the extent of power and authority exercised by court in particular matter. Issue which determines whether to knowledge. Kind noble Lord NIMR under citations of life. Equally see the law that in Abu Batos Street and other citations also supply in this regard. On the one, with respect to the alleged denial of right to fair hearing of defendants, the tenet of fair hearing is to the effect that both sides in the Latin margin or the that the party can not be a judge or the party cannot be a judge in its own court, as expressed in Mazin Judensi Kasaswa. Fair hearing is enshrined in Section 36 of the Republic of Nigeria and established by law and constituted in such manner as to secure its independence and impartiality. Also see the case of MFA versus Inoga citation supply, where it was held, and I quote, fair hearing within the meaning of Section 36 of the Constitution of the Federal Republic of Nigeria 1999 means a trial or hearing conducted according to all legal rules formulated to ensure that justice is done to the parties. It requires the observance of two pillars of the rules of natural justice, namely, or the Otaran parties and the Mojudes in Kasasua. Simply means that no judge should decide over a matter in which he has personal interest or involvement. Also, my noble lord, late Nikki Toby, DSCE of blessed memory in Island and Musa citations of life, held and initiated on the principle of fair hearing. The defendant claimed that he was denied his right to fair hearing by the court, foreclosing him in the entry of his defense. As the risk of repeating myself, I will repeat my ruling of 7th November 2025, wherein I recounted the history of this case and proceeded to foreclose the defendants. This matter was filed in 2015, and due to the delay as a result of appeals and other issues, same was assigned to this court in March 2025. Prior to this, in 2017, the defendant was alleged to have jumped bail and escaped from Nigeria, and for about 4 years, the defendant was not in Nigeria within the territory of Nigeria, which caused a stop to his trial due to his absence. In 2021, he was brought back to Nigeria to face his trial. However, the defendant became unruly and caused serious delay in the trial before my learned brother, Linyako J. The issue got to a head that the defendant began asking my learned brother to recuse herself from the trial on the basis of being biased towards him. The judge recused herself, and the matter was assigned to this court in March 2025 for trial. Upon adoption of jurisdiction, having in mind that this matter has stayed for 10 years and the interest of justice, I granted...
Being personal, but I want to assure you that somebody in that position ought to show some penitence, ought to show some remorse, ought to throw away arrogance and self-serving attitudes. The court is further urged to take judicial notice of the fact that the convict established Radio Biafra, a broadcasting platform operating on several digital channels, including mobile radio, Twitter, YouTube, Facebook, WhatsApp, blogs, and Instagram. It is a station with global reach. Evidence before the court, my lord, shows that when the convict was arrested on 15 October 2015 at the Tulip Hotel in Lagos, he was found in possession of broadcasting equipment. The conduct of the defendant through online publications, live broadcasts, and social media communications constitute act of incitement, encouragement, and provocation of terrorism as defined under the Act. It is the view of the prosecution, Lord, that without the instrumentality of the internet and social media platforms, the magnitude of destruction, division, and human losses recorded in southeastern states of Nigeria, including Lagos, would not have reached the level it attained. The digital platform becomes tools in the hand of the convict, tools of radicalism, ethnic hostility, and incitement to terror. Their amplified reach resulted in a coordinated transnational militarism or militarization of violence and destructions of public property across several states of Nigeria. The court has both the power and the duty to restrict further access to digital media through which the offenses were committed by making orders that prevent the commission of similar or related offenses, including forfeiture, confiscation, or restrictions of the means used to commit the act of terrorism. As a form of preventive control, the prosecution praised this honorable court to impose restriction on the convict's access to digital devices, online accounts, or internet facilities. In other words, my lord, anywhere he may be kept until his execution in obedience to the sentencing, if he has access to these devices, and they are cheap and easy and available everywhere in Nigeria, there will continue to be broadcast. Maybe he will claim he was not the one. At the moment, if you open to YouTube, you see a lot of rascals talking about the proceedings of the court, trying to twist and misread and mislead the people with what happened in court. So we're asking that your lordship should restrict him from having access to these devices. This honorable court, my lord, has the statutory power to prevent convicts from further committing offenses by making orders for the forfeiture, confiscation, and restriction by any means used for communication. We therefore pray that the court to order the forfeiture of all the broadcasting equipment, digital devices, and all electronic materials seized from the convict and currently in the custody of the Department of State Security, State Service. In particular, the radio transmitter Trans 50L, unlawfully imported into the country, should be forfeited to the federal government of Nigeria. My lord, we want to say, sir, with all respect, that it might be argued that access to information, access to digital devices may be argued within the constitutional rights, but it's not absolute. So therefore, sir, if your lordships want to order his restriction, your lordship may give him a right to acquire any, but with the permission, with the authority of National Security Advisor and the Controller General of the convict, for his safety, for his security, and for the protection of his life until your sentence is executed. I respectfully, sir, as prosecutor, plead with your lordship to direct that he be kept in the safest custodial center anywhere in Nigeria, because his safety is very important. Your lordship need to take judicial notice of what happened when Simon Ekpa was sentenced in Finland. There are lots and lots and lots and lots of talks and talks. The convict has enemies. He has friends. But no one can say the volume or the number of his enemies who may want to eliminate him. So we are asking, my lord, that your lordship order the government of the Federal Republic of Nigeria to keep him in the safest custodial center anywhere in Nigeria. You know, and if I may say with all sincerity, I am not too sure that Kuje, where there have been jailbreaks, will be the ideal place. So I'm urging your lordship, with all sense of responsibility, to preserve his life until he answers his sentence. So I thank your lordship, and I pray that the incidents of terrorism will cease from Nigeria, from north to east, to northwest, to north central, and as we see, may God spare Nigeria of disintegration. My Lord, I want to thank you. I want to appreciate you on behalf of my colleague, Adebayo Ojo, and Suraj Saida. We are grateful to your lordship for a well-researched, a well-reasoned, and a courageous judgment. Thank you, my Lord.
There is no doubt that the convict has waived his right to be present through his unruly attitude, the habitual unruly attitude to be in court when the judgment was read. But we must still give him opportunity to hear one or two things from him, but not personal through his person. Since his consultant is here and the offense has to do with death sentence, I will call his consultant, that was his lawyer before he converted him to consultant, if he has any allocutors to make on his behalf. Mr. Ejimako, do you have any allocutors to make on his behalf?
My Lord, being an officer in this temple of justice and not being properly dressed and not being his counsel of record, I will yield this very task to Honorable Obinna Agocha, who is better qualified than me, being the member of House of Representatives who represents Mazen Namdekano.
It's okay. Honorable, let me have your full name and restrict yourself to allocutors.
Yeah.
Allocutors is what will mitigate the sentence. Is our brother. Let us hear you. You tell us your name. We can't, because of your ruling behavior, deprive him of allocutors. Can I hear from you?
Thank you, my Lord. My name is Right Honorable Obi Agocha. I represent the good people of Iguano, Umahian North, and Umahia South Federal Constituency in the 10th National Assembly. My Lord, I am the direct representative of Mazen Nnamdi Kanu. That's why you see me here almost every time, showing presence and also showing solidarity with him. The matter has come to a closure for now. I'm not his lawyer. I wouldn't know whether they will seek appeal. But for now, my Lord, he's my brother. He's my friend. I went to school with him. We attended primary and secondary school together, though he was my junior. But it is my responsibility and obligation as a member of the National Assembly to represent him as well. My Lord, I plead for mercy, I plead for clemency, and I appeal for peace and for stability of not just the Southeast, but as well as Nigeria. Like the prosecutor said, Nigeria is bleeding over the last few days, and we must bring some of these issues to bear and to understand how to find common solutions to our common problem of terrorism. I also wish to appeal to the prosecution team that it is being done to Mazen Nnamdi Kanu. The other people out there also doing more worse than him.
Please,
sorry, sir.
I asked for a locutor.
Yes, sir.
Please, don't
so, I apologize, sir. So, I want the court to take judicial notice of that this trial has gone on for almost 10 years. Mazen Kanu is almost 56 or 57 years old now. He has been absent in his family life, his children, his community, his family. So I plead for my Lord to show mercy, to temper justice with mercy. And as we move forward, it shall be great for our country. Thank you very much for the opportunity. I'm a friend of the court, having come from the other side of the government. So thank you for giving me the opportunity to address the court. Thank you, sir.
Thank you. I will consider all this, and I will rise and come back by 10 minutes to 4. You may go and come back 10 minutes to 4 for the sentencing. I will rise and come back.